Imagine one of your employees is making a delivery at a customer's warehouse, and they slip on a spilled liquid, suffering a serious injury. The standard reaction for most employers and insurance agents is to sit back. You assume you have to wait patiently for the injured employee to hire a lawyer and sue the at-fault business. But waiting is an expensive habit. Leaving the recovery process entirely up to the employee often means leaving thousands of dollars unrecovered, which unnecessarily drives up your experience modification rate, or MOD. Colorado law offers a specific tool to bypass this waiting game. It's Colorado Statute Section 841-203. By applying this statute, you don't need to rely on the injured worker's timeline or their willingness to go to court. You can take direct control and recover those lost funds yourself. Step 1 is proactive identification. You need to manually audit your open workers' compensation loss runs to look for third-party liability. Specifically, you're scanning the accident mechanics for descriptions like car accident or slip and fall at client site, anything indicating someone else caused the injury. This flowchart illustrates the independent right of action. Colorado grants the payer of benefits the legal authority to sue the third party directly, creating a separate, parallel path for recovery. Notice how the employee's path drops away. The carrier bypasses the employee's decision-making process completely. Let's say your carrier has paid $100,000 for a claim, but the injured employee feels too nice to sue a business partner or a friend. The carrier can step in and pursue that $100,000 payout anyway. By aggressively auditing your loss runs and exercising this independent right, you remove the worker's personal reluctance from the equation and secure your bottom line. Finding a third-party opportunity is only the beginning. You have to secure your legal place in line immediately. To do that, the carrier must prepare and send a formal notice of lien directly to the at-fault third party's insurance provider. This calendar tracks the strict timeline you face. Colorado law requires this notice to be filed within exactly 30 days of the injury occurring. The most common mistake employers make is letting this window expire because they assumed they needed to wait for the employee to retain legal counsel first. This urgent 30-day rule applies even in the chaos of sudden accidents, like an employee being struck by a negligent driver while on the clock. Hitting this non-negotiable deadline legally locks in the carrier's right to recovery. It ensures a valid claim doesn't expire in administrative limbo. Now let's jump to the final phase of the claim, the moment the third party is ready to write the settlement check. This graphic shows how a settlement check is divided. As a first money state, after attorney fees, the carrier receives full reimbursement up front. Only after that lien is satisfied does the remaining fraction slide over into a bucket for the employee's additional damages. Sometimes employees and their attorneys might try to settle with the third party quietly to avoid paying the carrier's lien. Colorado provides a strict countermeasure for this. An employee cannot legally settle a claim without the carrier's explicit written consent. If an unauthorized settlement does occur, the carrier gains the immediate right to terminate all future workers' comp benefits for that specific employee. This severe penalty acts as a hammer. It gives employers the ultimate leverage to ensure their lien is respected and fully funded before the final paperwork is signed. To review, Step 1 is to proactively audit your open loss runs to spot third-party liability. Step 2 is ensuring the notice of lien is filed within that strict 30-day window. And Step 3 is utilizing the settlement approval hammer to enforce your status in a first money state. By executing these proactive steps, employers stop waiting. You capture recovery opportunities before they expire, and you actively protect your experience mod. If you're an insurance agent needing more training on these tools, visit workcompprofessionals.com. And for employers seeking practical guidance to control your costs, go to conquercompcosts.com to take control of your